Visit ILMS Academy for various courses from contract drafting, RTI, labor law, GST, and more. Get certified to enhance employability. Visit ILMS Academy for various courses from contract drafting, RTI, labor law, GST, and more. Get certified to enhance employability.
In this case, the Constitution bench arrived at its conclusions on the validity of the Coking Coal Mines Nationalization Act 1972 and upheld the same. But while doing so, in paragraphs 10 to 14, observations were made with regard to the judgment of this court in Minerva Mills. In fact, paragraph 10 reads as follows, quote, "We have some misgivings about the Minerva Mills decision, despite its rare beauty and persuasive rhetoric," unquote. In my view, those observations were wholly unnecessary as they lose sight of the outstanding judicial statesmanship exemplified in the majority judgment authored by Justice Y.V. Chandrachud, Chief Justice, in Minerva Mills. One has to bear in mind the fact that the hearings in the case of Minerva Mills as well as in Vaman Rao were proceeding contemporaneously but before different benches, both headed by learned Y.V. Chandrachud, Chief Justice. Realizing the import of the separate opinion of Justice Krishnaiyer in Ranganatha Reddy and the likelihood of the said opinion gaining momentum in Minerva Mills as well as in Vaman Rao, and rightly so, the then learned Chief Justice took upon himself the responsibility of pronouncing the operative portion of the judgment in Minerva Mills in May 1980 and supplementing the reasons in July 1980. And the judgment in Vaman Rao was delivered in November 1980, just prior to the retirement or demitting office of Krishnaiyer J. It is another matter that Justice Bhagwati frowned upon such a strategy adopted in Minerva Mills and in fact penned a common separate judgment in Minerva Mills and Vaman Rao, although the issues were distinct, though overlapping in certain areas, which were minority opinions. In Vaman Rao, only a short order was passed by Justice Bhagwati. Justice A.N. Sen, by his concurring judgment, however, opined that since there was a review of the judgment in Minerva Mills pending before this court, he refrained from dealing with the said decision and from making any observations or comments on the same. This is with regard to the interplay between Minerva Mills and Sanjeev Coke. Basanti Bai. In this case, the court considered the correctness of the judgment of the Bombay High Court, by which the High Court had declared subsections 3 and 4 of the MADA as void and had given certain ancillary directions. This court at the outset proceeded to observe in para 13 of the judgment as, quote, "We shall proceed to test the validity of the argument, keeping aside for the time being the observation in Sanjeev Coke Manufacturing Company versus Bharat Coke Coal Limited. The question whether an act is intended to secure the objects contained in Article 39B or not does not depend upon the declaration by legislature, but depends on its contents. Reference was made to Ranganatha Reddy, which dealt with the question whether nationalization of bus transport was covered by Article 39B, and to Justice Krishnai's observations only in a limited way. It was observed that MADA was protected from challenge owing to the applicability of Article 31C of the Constitution, and it was immune from the challenge under Articles 14, 19, and 31 of the Constitution. It was further observed that land ceiling laws, laws providing for acquisition of land for providing housing accommodation, laws imposing ceiling on urban property, etc., cannot be struck down by invoking Article 21 of the Constitution. Consequently, the judgment of the High Court was set aside to the extent that subsections 3 and 4 of sections 44 MADA had been held unconstitutional and struck down, and the appeal was allowed. What is significant about the judgment in Basanti Bai is firstly, the case was considered in light of only that portion of the judgment of Justice Krishnaiyer which dealt with the aspect of distribution and did not discuss other aspects of Justice Krishnayer's opinion, which dealt with the judgment, which dealt with the question whether even private property can be equated as material resources of the community. Secondly, in this judgment, it has been expressly stated that to test the validity of MADA, the observations of this court in Sanjeev Court were to be kept aside. Justice Venkatramaya, who is the author of the judgment in Basanti Bai and a member of the 5-judge bench in Sanjeev Court, distanced himself from the observations made by Chinnappa J in Sanjeev Court, as well as the other observations of Krishnaiyer J in Ranganatha Reddy. However, what is common in all these cases is the fact that nationalization of contract carriages in Ranganatha Reddy, nationalization of coal mines in Sanjeev Coke, and reservation of land for public amenities under MADA were all upheld and sustained on the touchstone of Article 39B and protected from attack by virtue of Article 31C. While Justices Krishnaiyer and Chinnapareddy supported their reasoning on the touchstone of the word socialist in the preamble of the Constitution, Justice Venkatamaya and Basanti Bai considered the validity of MADA, rehorsed the observations made by Justice Chinnapareddy in Sanjeev Coke, and selected only certain portions of separate opinion of Justice Krishnaiyer in Raghunatha Reddy. Thus, this court was able to consider the validity of MADA on the strength of Articles 39B, read with Articles 31C, without taking note of many of the observations in Raghunatha Reddy and no observation in Sanjeev Coke made by the learned judges on the basis of their socialist philosophy and on socialism. Basanti Bai is a judgment which was delivered in the year 1986 when perestroika was taking place even in a country such as Union of Soviet Socialist Republic, the home to socialism. And there was also a beginning of a new thinking in India too, commencing with 5 technological missions leading to the reforms of 1991, which I have discussed in the earlier part of my opinion. Then I have given my because it's as usual, my judgment is very long. Therefore, for a clearer understanding, I have given a summary of my conclusions and my views to the conclusions of Honorable the Chief Justice. As already said, I am agreeing in the first part and I have elaborated on the second part. Then I say what is significant is that the judgments in Ranganatha Reddy as well as in Sanjeev Coke upheld the respective nationalization acts. Therefore, on merits, it cannot be held that Sanjeev Coke violated judicial discipline. One cannot lose sight of the fact that in Sanjeev Coke, this court did not decide the case only on the basis of the opinion of Justice Krishnaiyer in Ranganatha Reddy, but on merits on the validity of the Nationalization Act. Therefore, Sanjeev Coke is good law insofar as the merit of the matter is concerned. Then I have said privately owned resources except personal effects as explained above can come within the scope and ambit of the phrase material resources of the community, provided such resources get transformed as resources of the community as discussed above. To reiterate, it would not include personal effects as discussed by me in paragraph 7.6. In my view, the judgments of this court in Ranganatha Reddy, Sanjeev Coke, Abu Kaur Bai and Basanti Bai correctly decided the issues that fell for consideration and do not call for interference on the merits of the matter as explained above. The observations of certain judges in those decisions would not call for any critique in the present times, neither is it justified nor warranted. Reference is answered in the above terms. I must place on record my sincere appreciation to the learned Attorney General, learned Solicitor General and their teams, learned Senior Counsel and learned Counsel appearing for the respective parties, and learned Instructing Counsel for their valuable assistance to this bench. Thank you.
Immensely grateful.
I'm going to be short. There are 4 points. As far as Article 31C is concerned, I totally agree with the view of the Chief Justice. And as far as the application of Mafatlal is concerned, I again agree. Mafatlal is in the nature of an arbiter and it's not applicable. The third is regarding judicial discipline, about which a lot has been said. Both not being followed in Ranganatha Reddy as well as in Chinnapareddy's judgment in Sanjeev Coke. Now, to that, I totally disagree for the reasons which I'll just state in few words. The question now is that when in Sanjeev Coke, the 5-judge Constitution bench unanimously followed the minority judgment in Ranganatha Reddy, did it violate judicial discipline of not following the majority, but the minority decision? In my opinion, it did not break any judicial discipline, since in Sanjeev Coke, the 5 judges did not go against the law laid down by the majority judges in the Ranganatha Reddy but only adopted the logic of the three judges, on which the majority of four judges was silent. Chief Justice. And as far as the application of Mafatlal is concerned, I again agree. Mafatlal is in the nature of an obiter and it's not applicable. The third is regarding judicial discipline, about which a lot has been said, both not being followed in Ranganath Reddy as well as in Chinnappa Reddy's judgment in Sanjeev Kok. Now, to that, I totally disagree for the reasons which I'll just state in few words. The question now is that when in Sanjeev Kok, the five-judge Constitution bench unanimously followed the minority judgment in Ranganath Reddy, did it violate judicial discipline of not following the majority, but the minority decision? In my opinion, it did not break any judicial discipline, since in Sanjeev Kok, the five judges did not go against the law laid down by the majority judges in the Ranganath Reddy, but only adopted the logic of the three judges, on which the majority of four judges was silent. It is first difficult for me to even come to the conclusion that the four judges in Ranganath Reddy entirely disagreed with the minority opinion of Justice Krishna Iyer. It merely says we must not be understood to agree with all that he has said in his judgment in this regard. This is not exactly a disagreement. The majority of the four judges chose to remain silent on the subject. It cannot be said that the four judges in any way said anything contrary or in opposition to what was laid down by the three judges in Ranganath Reddy. Therefore, no judicial discipline was broken by Justice O. Chinnappa Reddy when he authored the unanimous judgment in Sanjeev Kok by adopting the logic of the three judges in Ranganath Reddy. The logic, however, is now very clear. In cases where a judge or judges of the Supreme Court in minority has given a decision on a point on which the majority has remained silent, that it would be binding upon the high courts and all the other courts, and for this court at least it will have persuasive value. The five learned judges in Sanjeev Kok relied upon the decision of the minority judges in Ranganath Reddy as they were persuaded by the logic and the interpretation given by Justice Krishna Iyer to the phrase material resources of the community. Now, regarding the main question which was there before us, that whether privately owned resources are a part of the material resources of the community, I totally agree with the findings which have been given by in Ranganath Reddy and reiterated in Sanjeev Kok. And for this, I'll just there is a expression which is attributed to Justice Louis Brandeis of Supreme Court, although he never said it in any of his opinion. And this is, he said that we may have democracy or we may have wealth concentrated in the hands of a few, but we cannot have both. Now, this expression finds reflection in our Article 38 and 39 as well, on which my judgment is based. I am of the firm view, unrelenting opinion, that the interpretation given by the three judges in Ranganath Reddy and adopted unanimously by the unanimous judgment in Sanjeev Kok is the correct interpretation of material resources of the community. For the reasons, the meaning which must be given to material resources of the community is what has been given to it in Ranganath Reddy by the three judges and what has been followed by the Constitution Bench decision in Sanjeev Kok. To my mind, this has been the correct interpretation of the phrase material resources of the community. To reiterate what was said by Justice Krishna Iyer and Ranganath Reddy, material resources of the community in the context of reordering of natural economy embraces all the national wealth, not merely natural resources, all the private and public sources of meeting material needs, not merely public possession. Everything of value or use in the material world is material resource, and the individual being a member of the community, his resources are part of those of the community. It is for the legislature to decide how the ownership and control of material resources is to be distributed in order to subserve common good. Once the expansive meaning of material resources of the community is determined, there is no necessity of drawing further guidelines for the legislature to determine as to what will constitute material resources. How to control and distribute a material resource is also the task of the legislature. But while doing so, what has to be seen is that the control and ownership of the material resources be so distributed that it subserves common good of the community. If it does not, then such a legislation can be struck down as the judiciary is not deprived of its powers of judicial review. The legislation is to establish a nexus with the principles specified in Article 39B and C to be a valid legislation. This is the law in terms of Kesavananda Bharati and Minerva Mills. To put it differently,